Criminal Due Process by Rachel, Helen, and Rod.
King Perry.
Arrest is the act of depriving a person of their liberty, usually in relation to an investigation or prevention of a crime. This occurs when a person has been taken into custody and is no longer free to leave. The key to an arrest is the exercise of police authority over a person. When a police officer can arrest is when the officer observes a crime, has probable cause, or has an arrest warrant.
Booking. The procedure by which law enforcement officials record what happened during the arrest and the charges. The suspect is brought in. There will usually be a photograph, height and weight, and fingerprint will be taken. Information concerning the suspect's identity and other facts will also be copied down.
In a preliminary hearing is proceeding after a criminal complaint has been filed by the prosecutor or to determine whether there is enough evidence to require a trial. Typically is described as the trial before the trial. The judge listens to arguments from the prosecutor and the defendant's attorneys. Prosecutor may introduce evidence or witnesses' testimonies to convince the judge that the case should go to trial.
Arraignment. The accused criminal is brought before a judge and is read the charges against him or her. The defendant will plead guilty or not guilty. They also go over bail and future proceedings.
Plea bargaining is an agreement between the prosecutor and the defendant in which the defendant pleads guilty in order to receive a lesser offense. There are some reasons pleas are used, such as the courts are overcrowded, prosecutors have too many cases, and the defendants save time and money by not going to trial. There are 3 types of pleas. Charge bargaining, which is the most common, and they agree to plead guilty to a smaller crime. A sentence, defendant pleads guilty of the stated charge for a lighter sentence. Fact, they agree to stipulate certain facts to prevent other facts from being introduced.
Trial. The defendant and the prosecution have the choice whether to be tried by a jury or a judge. Some allow as small as 6 people on the jury. The jury is selected through a Q&A process called voir dire. The prosecution and defense will present their evidence and opening statements.
Very excessive.
The verdict is the official decision of a jury. The decision is made after a lot of considering by the jury in the courtroom. Usually requires unanimous decision.
Oh, I'm so sorry.
Yeah.
Appeal is when the person will ask for a higher court to review the case for legal errors.
This applies to a higher court for a reversal of decisions of a lower court. Filed by the losing party, no new evidence can be admitted. Is filed in the hopes of a verdict change.